Good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna PC. This is our Thursday phone call for the community. We do this every Thursday, once on LinkedIn and once on our private bridge, 202-800-8394, always at 12:30 p.m. Eastern Time on Thursdays. Okay. So this is our private bridge call. We do it like this. First, I go over the questions that I think are frequently asked questions. I'll answer those. I will invite follow-ups on those questions. No new questions, just follow-ups. Okay. Then I'll answer all the questions that have been posted turn by turn. And after which, we will take new questions when all the questions that have been posted have been answered. And like I said, I'm going to lock the conference once I have enough people. Actually, I have enough people even now, but it's only 12:30. So I want to wait another 4 or 5 minutes before I lock the conference. Okay. So stand by, and I'm going to begin by talking about what I think today was, only one frequently asked question, which was, let's start. The path for an entrepreneur from STEM, OPT, or H1B. So let's just talk about the options for an entrepreneur, whether they are inside the USA or outside the USA. Many of the options I'll talk about are equally for people who are here or who are coming from outside the United States here. So as you know, there are two kinds of visas when you want to come to the US. There is a visa that allows you to come temporarily for a certain amount of time for certain purposes. For example, F1 visa, you use it to come to study. H1, you use it to work, and it's all limited. There are controls on the visa. You cannot do anything you want. The purposes for which the visa is to be used or the status is to be used are defined. So you can't just do anything you want. So for example, if you're a student, you cannot be running a business on the side except under very limited circumstances. And so we'll get into that. There are non-immigrant visas, which are just for temporary defined purposes. And then there are immigrant visas, which is a green card, which is to stay in the United States permanently. That allows you to travel, come back, as well as do every activity that a US citizen can do, except run for the office of the president, pretty much. Okay? And you can't vote in the elections as a green card holder. But once you become a naturalized citizen, which is about 5 years after you get your green card, you can then actively participate in every part of the democracy again, except running for the office of the president. Okay. So first of all, what are the options we have as a non-immigrant? The first option is B1. B1 is a business visa which allows you to come to the US to shake hands, sign contracts, but you can't really work. Okay? You can set up the infrastructure. Typically, you get about 6 months at one time. You come and you set up the business, but then you have to start looking at options. How can I stay and work here? And these are the options. The rest of the options that I'm going to talk about usually are used by people to have a longer time to work. One option is called International Entrepreneur Rule. So basically what that does is, if your business has been established in the last 5 years and you have substantial ownership, 10% for one purpose, 5% for another person, you can start the process of parole, which gives you 30 months of permission to stay in the US, 2.5 years, and it can be extended for another 2.5 years. This is not a permanent option, this is a temporary option. Just giving you the broad options, and then you can see more in depth which works better for you. Some countries have a treaty with the United States. It's called the Treaty of Trade and Commerce. Okay. Under that, there are two kinds of visas, E1 and E2. E1 is for traders who are actively trading with the United States from their country, It can be a trade in goods or services. Okay. And more than 50% of your total volume of the trade is with the United States. That's an E1 visa. But remember, your country must have a treaty. Like India does not have a treaty. Pakistan does. Bangladesh does. Many other countries, all of Europe does. But India does not have an E1 or an E2 treaty. E2 is called treaty investor. Maybe $100,000, $150,000 investment. You can get an E3 for 3 years. E visas, derivatives, spouses also get work authorization. So E2 is another very good option. There is no limit to how many times you can extend. And if you keep investing money into E2, at some point you can convert that into EB5 green card. Okay. So we talked about international parole, entrepreneurial parole. We talked about B1. We talked about E1, E2. Can you start your business, which is the question today? Can you start your business on STEM OPT or H1B? The answer is STEM OPT for sure. No question about it. On H1B, currently, unless you are a majority partner or majority stockholder, it should be possible. If you are a majority stockholder, it gets a lot more complicated because you have to have an employer-employee relationship. If nobody can fire you, how can you be an employee, right? So many times we can set up a board of directors who has the power to fire you. But remember, your work as an employee of the company, even if you're a majority stockholder, should always be in your own field. You can't just work in any field. It's the same for F1 OPT. So if you are a software developer and you have a degree in computer science, you cannot be working as a artist, for example, because that's not your field. It's got to be in your field, okay? Problem with STEM OPT, with OPT people is it's much more difficult to get STEM OPT extension through your own company. Again, there's an employer-employee problem. There's got to be a plan for training, etc., that has to be signed by your supervisor. It's a lot more complicated. H1B might be a little easier, but starting business on OPT is still complicated. There are regulations pending as of today, February 1st, 2024. These regulations will make it a lot easier for entrepreneurs to hold stock, even majority stock in their own company and conduct business, okay, while they're on H1B. There's an option called L1. L1 is if there are two companies, foreign company which is outside USA and local company in USA, which are related to each other, the business they do can be totally different. It doesn't have to be the same business. One company is selling machine parts. Another company is providing healthcare services. No problem. The employee who is coming either has some very special knowledge of the company or they are managerial or executive level employees. Another great option, spouse automatically gets work authorization, and the L1A can easily lead to a green card. Very good way to go. The last one I want to talk about is O1. Sometimes you can qualify based upon your extraordinary achievements. You typically get up to 3-year approval first time around, and you keep getting 1-year extension on an ongoing basis with no maximum duration. And none of these have lottery or any of those limits. Okay. For green card, you have the EB1A, which is I'm an exceptionally qualified individual. EB2, national interest waiver. What I'm going to do has wide impact on the US interest. 3, EB5, where I'm investing as of today's date, $1,050,000 in an ordinary area or $800,000 in a targeted area. So these are some of the options as entrepreneurs. I wanted to quickly run it by. The question that was posted was, I am on F1 OPT, STEM MS degree. If I do a startup, I'll be performing role directly related to the degree. Would having a board of directors be sufficient during STEM OPT? Nobody knows the answer to that question. I certainly hope so. And if you have multiple people involved in the company as equity holders, as stockholders, as your partners, that could become easier. I certainly think so. Remember, you also have to be e-verified. That's also required. So don't forget that part. Number 2, if I apply for EB to NIW, can I immediately shift to a non-tech role like a CTO or a CEO? Or do I have to wait for 6 months before doing that? The answer is yes. You have to wait until, unless you're, well, let's just take that a step back. The way I would do it, I would first do the OPT as well as do the H1B that year. I would then see if there's a possibility of STEM OPT for the same company if you have multiple participants. And each year I'll keep trying H1B. Okay. NIW should be applied the very first year as quickly as possible. If you are not born in a very backlogged country like India, NIW is a great option. If you or your wife were born in a country other than India, NIW could be a great option. Okay. NIW requires, I have an article on this. Just Google my name, Rajiv S. Khanna, Economic Times. I wrote a brief article that talks about what the advantages of NIW are, even for people who are born in India. So look into that. It is definitely worth a shot. If you were born in a country other than India, or your wife was, or husband was born in a country other than India, you might be able to file 485 right away. Can you change your role? If you are NIW is not tied to a particular job. It's tied to a field. So let's say you got NIW for example, you are working in critical and emerging technologies, and your work is going to affect a lot of people. It has a non-local impact. You could be changing jobs, no issue at all, as long as the field is the same. That's the huge advantage. Oh my God, we have a lot of people. I just didn't realize. Okay, I'm going to lock the conference. I have a lot more people than I can do in one call. I'll do my best, folks. Just 1 second. Let me lock the conference. I forgot to lock, so kind of got away from me. 1 second. Here it is. Lock it.
The conference is now locked.
Okay. So yeah, if you have done an NIW, you can definitely, once you you get your EAD, you can change to any role as long as it is within your field. Okay. If the startup fails, does that discontinue my 485? Probably not. This is a little difficult to say, because remember, like I told you, this is not tied to your particular job. So also with the particular employer, right? Makes sense? So that's why it could be a great option for many people. Press *5 if you have any follow-up question. No new questions, please. Only follow-up to what I've discussed. Okay. So I have one from area code 858, which is California. Yeah, California, go ahead. I can hear you.
Yeah, good afternoon, sir. Can you hear me?
Yes, I can. Please, go ahead.
Okay. Yeah, so follow-up question. So can an NIW application and the normal perm application go in parallel simultaneously? Or, I mean, not simultaneously, but let's say the perm application was filed and then an NIW can be initiated after that?
I have
methods.
I have done it many times. Although there is a conflict somewhat, because one of the things we say in NIW applications is that a labor cert or perm application should not be required. Okay. However, merely filing it has no impact especially where I want to cut ties with one particular employer and be tied down to one particular job. I think personally, I've never had any problem. I've done cases like this before. So far, so good. But if you look at it from a classical perspective, yes, it could be a problem. Okay.
Mm-hmm.
Anything else?
Okay. And for NIW, what all things would
Sorry, you cut off. I don't know what
the
you just said.
laterals?
Hello?
Yeah, sorry. I was saying that for NIW. Hello. Yeah, is my voice audible?
Yeah,
Hello?
now it is. Go
Hello?
ahead, please. Yeah, I can hear you. Keep going.
Yeah, yeah. Yeah, thank you. Yeah, so just a quick question. So for NIW, I have read the requirements, but I just wanted to confirm, do I also need letters from previous employers stating my skill sets in this particular emerging field?
That is not the focus of an NIW. The focus of the NIW is what can you do for the USA, which is beyond just local impact. Okay, I'll give you an example. Today I spoke with somebody who works for a very large county, managing their entire SAP farms or whatever, all their SAP work. Now, my question to her was, look, I would love to do your NIW, but I can't prove that the work impact goes beyond the county. How can I say it is national interest? On the other hand, we had a case where this gentleman was making devices, wearable devices for body dehydration without any penetration or needles. But that device was being sold in all 50 states. Government didn't raise any issues. They didn't even send me an RFE. They just approved the national interest waiver. So it's a little complicated, and it's definitely sometimes a toss of a coin, because one officer might say, oh, yeah, great case. Another officer might say, oh, no, this case is mud. I'm not approving it. So who knows? Definitely worth a shot if your work has non-local impact. By the way, I'm waiting till the end of April because Biden administration has told government agencies to create options for people on critical and emerging technologies list to work in the US. And they gave 3 time periods, 90 days, 120, 180. 180 ends around April end. So I'm hoping that we'll see some good things happen. Make sense?
Yes. Yeah, thank you. Thank you very much.
You're welcome. Good luck. Okay. So any other follow-up questions, folks? And I'll get started otherwise. Okay. So I don't know how many people I'm going to be able to assist today. We have about 10 or 15 people more than I can usually help. Maybe no, actually more than that. Almost 20 people more than I can help. Okay, so let's go back to first question that was posted. Lost H4 and H4 EAD due to husband's layoff. Change of status to B2 and H1B transfer. Do I need to file a new 760 for H4 EAD upon returning to the US? So that's a question I don't know the answer to. I think when you do a change of status from H4 to B2, I think your EAD is lost. I think when you come back to the US after a trip abroad, and even if you return on H4, I think you'll have to file EAD again. I have no data on this. I have no known, at least not to me, any comments from the government on this. Okay. But I think when you have a change of status, that EAD would have to be refiled. Okay. You have a follow-up question on that? Let's see. This is area code 530. 530 is also in California. Yeah, California, go ahead, please.
Yes. So my question is actually similar. It's regarding H1 to H1 transfer.
Right.
So I am actually filed as an industrial designer on my H1 job, but I am looking for new opportunities in the field of UX design.
Okay.
So both of them are design jobs, but like when you look at the FLC data center, they're categorized as different jobs. So I wanted to know if that transfer is possible, or are there any problems that could occur?
Let's start with the practical steps first. So if you go from one H1 to another, but you don't move Actually, even if you move, it's not a big deal. But let's say you be conservative and you don't move until the H1B is actually approved. That would be a good way to go. Because UI UX designers have always had a problem. It's always a toss of a coin. Are they going to get their H1B? Are they not going to get their H1B? Okay. Even industrial designer can be a problem getting an H1B. Why? Because the government sometimes comes and says, well, what degree do you require for this job? Okay. So it can always be an issue with any jobs that are non-classical, like mechanical engineer, everybody knows. Electrical engineer, either your power or your computer, everybody knows. Okay. So it's just when there are non-classical jobs, for a while we had a lot of problems with control systems. Because control systems, you can be mechatronics, mechanical, electronics, electrical, software engineer. All of these can qualify to be a control engineer. Government gave me hell, but we did get all the approvals. So these jobs are still evolving. I would want you to have a detailed discussion with your lawyer. But the best thing you can do is not to move until your case is actually approved. All right? It can be done for sure, no question about it.
Yeah, actually, I was thinking about a transfer, not a completely new H1B. I don't know if
The same thing.
if
Transfer.
I was not clear.
There is no difference in transfer and a completely new H1B. Same thing. Okay?
Right. So just one last question. So would you recommend in this position to keep looking for industrial design jobs rather than UX, because that's what my master's is in?
You can certainly try. Like I told you, as long as you don't move, actually, even if you move and the old job is kept open, you can come back to it. But if you don't move, that's even better.
Okay.
Wait until it gets approved, then join. Okay.
Right. Makes sense, yes.
Good luck. And actually, I've done a bunch of UI UX designers. All of them went through. Okay. But we know where the
great.
pain
Then
points.
I'll definitely reach out to you.
Not to me necessarily, any lawyer can do it, as long as they understand the issues. I'm not trying to sell ourselves to you. I'm just telling you that that's our experience. We had to be careful. We had to make sure we understood. Some of them look more like a software engineer than a graphics designer. Some of them look like a graphics designer. And some of them look like a human factors engineer. There are all these variations within that theme. Some of them look like systems analysts. So we have to be very careful where we are going with the case. All right?
Okay. Thank you.
Good luck, sir. All right. Let's go on to the next question. We did the frequently asked question. So B2 visa rejection under 214B. So 214B simply says this. This is Immigration and Nationality Act section 214B. It says, look, we have looked at your B1 or your F1, F2. We just don't think you are going to come back. Okay. So that's 214B, immigrant intent. Can this be reversed? I think it's very difficult, but I have personally heard many stories where people applied for an F1 the first time or a B1 the first time, and they were denied, but then they were approved, most mysteriously. Okay. So should you try anyway? Absolutely. What are the possible reasons? Just the judgment call of the consular officer, the visa officer. So my mother's brother, Mama, B2 got rejected to 14B. He wanted to just come for a 3 weeks vacation. Visa officer just asked, purpose of visit, how much are you earning? Have you gone out of India before? No. Why are you going alone? Etc. Uncle is 45, well established. Counselor rejected the application. What are the reason? The reason is just a subjective call that the officer doesn't believe your uncle. How can he overcome? The officer told you how he can overcome. Go to UK, go to Bahrain, go to any of the neighboring countries a few times, then apply again. He's had international travel, right? How soon can he apply again? Nobody knows the answer to that question. There used to be a rule that you can't apply for 6 months until 6 months after denial. But that rule has been removed. I would say that let him take a few foreign trips and then do it. Apply in the same embassy or other, same embassy, same consulate. If you file a DS-160, then cancel, is it counted as, have you ever applied for a US visa before? That's a very good question. I'm not sure. If in doubt, always say yes. So I have to look at exactly what the DS-160 form says. Have you ever applied for a US visa before? Well, he's already applied and been denied. That's different. But I think, I don't know the answer to whether DS-160 filing alone counts as a visa application. I tend to always err on the side of too much disclosure. Okay. *5. If you have a follow-up question on this, press *5. Next question, travel predicament, switching from F1 to H4 after change of status within the US. So I changed from H4 to F1. It's the other way around. H4 to F1. Due to personal reasons, I'm traveling to India. I don't want to be on F1. Can I travel back on active H4? Absolutely. So even if you change status from H4 to F1, when you re-enter using H4 visa, you are back on H4. No problem at all. Yeah, that's fine. I don't see any problem at all. Because your H4 is expiring in August and you'll be coming before then. I don't see any problem, Shikanji. *5, if you have a follow-up question, yeah, just come back on your H4 visa. Okay. Next question. F1 student helping family business. I think you talked to me. Are you in the call? Press *5. If you're in the call, press *5. Yeah, I'm pretty sure we did a consultation for you yesterday, I think. You had called for a consultation after posting this message. So what I told you was always tell the truth and nothing but the truth. You'll be fine. And then the next question is timing for H1B filing. Can the employer file H1B before graduation? Dental student. Yes. As long as by the time you file your H1B application, so lottery can be applied. But when you file the H1B, you must have the degree in hand. When I say degree in hand, I mean your requirements are finished. You don't have to have the diploma itself. You'll get the diploma in August 24. I would, if you can get a letter from your school that says all your educational requirements are finished and you are just waiting for the diploma to be awarded, that is good enough. Okay, so you must have that before you file your H1B or when you file your H1B. For lottery, you don't need that. Press *5 if you have a follow-up question. All right, just 1 second. Next question, number 8. H4EAD approval time, understanding H1B sponsorship in consulting, and USCIS classification for mechanical engineering in the automotive industry. My spouse has applied for change of status H4, H4EAD at the same time. How much time does it take to approve EAD? I have no idea. Many months. Is there anything we can do to expedite it? Sure. If you Google USCIS expedite criteria, it tells you what the criteria for an expedite request are. We've done it before. It's complicated, not always guaranteed to work, but definitely worth trying. I'm new to the consulting industry and I need, to know how does H1B sponsorship work. They keep using the term vendor, client, and consultant. All that you can find out online. You don't even need me for that. That's basic stuff. Does mechanical engineering professional in automotive industry come under emerging technologies? I think some of them do. From what I remember, if you are a part of, there are several, I think there are some advanced engine technologies. There are energy technologies, some of them. Then there are, if I remember correctly, robotic processes. And there were also sensors, some kind of sensors. So mechanical engineer in the automotive industry could be under many different classifications. So the answer is maybe yes. Okay. Rajiv ji, you are here. I know you talked to me earlier. Press *5 if you have a question. Press *5. Area code 614. Yeah, Ohio, go ahead, please.
Hello, Mr. Khanna.
Hello,
So
sir.
my follow-up question is when an applicant is allowed to contact USCIS in order to expedite the expedited, like this application needs
So
to be
if you
expedited.
look,
This is under no humanitarian or any other
yeah,
certificate.
if you look at the expedite criteria, first of all, your economic need may not be that big a factor, because if you are on H4, your husband or your wife is supposed to be able to support the family. So I think that's a bad argument that we need the money. That could create an issue for you. On the other hand, when you are doing it for the employment or the employer, it's a different situation. One example is if you are working for a non-profit that is doing a lot of good work and they need your services right away, or you are working on a government contract or supporting a government contract. So these are some of the examples. Just because you need it is not a good enough reason usually for an expedite. Okay, the government did say during COVID times.
Right. So I am not.
Go ahead.
Yeah, go ahead, sir.
Yeah.
I was saying I'm not falling under any
Yeah,
classification, but
then
I
you
was
can.
looking for after how many days we can ask for.
No, you can ask for an expedite anytime. Sometimes I even send in a request for expedite along with the H4EAD. So there's no time limit on it.
But the DOS said like if there is a particular time, if you do it before them, they get annoyed and they do anything.
I am not
so
in
there
this.
is certain timeline before that you cannot
hang on. I'm not in this world to be polite to the USCIS. I just have to obey the law. Whether they get annoyed or not annoyed doesn't matter to me. I'm here to make my case. Either I have a case or I don't. I'm not aware of any particular deadline for an expedite request, but there certainly is a deadline for asking for the status and trying to make them move. That only happens if your EAD has gone beyond the expected time. So that's a different thing altogether. Expedite can be requested at any time. Okay.
Okay.
Good luck, sir. You're welcome. Let's go to Texas. Texas, area code 979. Go ahead, please. Texas.
Hello, Rajiv.
Hello, ma'am.
So I had a question. So for a H1 transfer with a consulting company, is there a way that they can have me as a remote worker and not?
Yeah, I'm not going to
specify a
answer that
specific
question.
address?
Hang on. Ma'am, I'm not going to answer that question. That has nothing to do with what I discussed. So wait until I call upon everyone to ask general questions. Please don't ask me unrelated questions. Only ask me what I have just talked about. Okay? So wait.
Okay.
Area code 312, do you have a follow-up question? Illinois, 312. Hello? Area code 312, I can hear you. Hello?
Hey, sorry, no, that was a general question. I can wait.
Okay, just wait, please. Let me finish the question that I posted. Then I'll invite general questions. H1B overstay, future visa options, I-140 utilization after extension, etc., etc. Note, I've been very honest in my H1B filing, no problem with extension in the past. Like to know, number one, would there be any bar on me if I overstay more than 240 days? Well, if you filed an H1B extension timely, like you said you did, there's no problem. Okay. So I don't see any issue. You have a permission to work for up to 240 days if you are filing for an extension without change. But if it is an amendment or a transfer, you can work as long as it is pending. Okay. So yeah, no penalty, so I won't answer the other two questions. Then I had my H1B valid till May 2017. I-140 approved, filed for H1B extension, filed H1B amendment, left USA. As I had already, you shouldn't have left, there was no need to do so. After I left, RFE was issued, employer withdrew. Oh, great. Employer was serving jail sentence for visa fraud. Excellent. And money laundering. Okay. So I don't think you should have any impact of the employer's wrongdoing if you were not involved in it. Other than that, I don't see anything extraordinary in your situation. Just get another H1B transfer. It should work. Press star 5. If you have a follow-up question, press star 5. Okay. Next question. Adjustment of status concerns. Leaving the US on H1B with approved EAD-AP and future steps for green card while in India. I'm currently working on H1B and I have a priority date of 2014 under EB2. Working for the same employer last 11 years. Filed AOS in 2020. Oops, sorry. Hold on a second. I just lost my place. Bear with me a moment. I just switch screens. Here we go. Which question was I on? B2, the travel predicament. Oh no, we did that already. That was Rajiv Singh's question. We did that. We did this one too. Here it is. I'm currently working on H1B, priority date this. 2020 I filed AOS. I have my AP EAD approved, but I'm working on H1B. Wife is on parolee status. 2 kids, both US citizens. I want to leave my job, move back to India for family reasons, but I do intend to come back. Will my application be abandoned if I leave the country? Well, you can convert it to consular processing. You can have your lawyers file Form I-824, or you can keep renewing your EAD AP. Yeah, that's also, well, not EAD, just the AP. Can you process the green card living in India? Sure, you have to convert it to consular processing. You will need an offer letter from the employer who filed the initial I-140. Because if you are, unless you are doing adjustment of status and you keep coming back, you will not be protected by AC-21 in consular processing. Okay. So if you withdraw your green card, you should be able to keep your priority date still, or just convert your case to consular processing. But then the original employer who filed the I-140 should be able to take you back when you get your green card. It's a little complicated. Talk to your lawyers, make sure you're doing it correctly, but in theory, it's possible. Star 5, if you have a follow-up question, press star 5. Okay. Area code 412, Pennsylvania. Let's see. Go ahead, Pennsylvania, I can hear you.
Yeah, so hi Rajiv. My question is, I have my EAD-AP valid till January 2029. So is it possible for me to just stay in India for those 5 years and come back on EAD-AP and then keep renewing it that way and without changing it to consular processing?
I think you can, but the two questions that come to mind are, number one, if the employer has a permanent job for you, why are they letting you go for so many years? Okay. And number two,
no, it's my choice.
Yeah, but it's how is the employer getting the work done while you're not there? Okay. So that's why I said, hold on. That's why I said talk to your lawyers about the details. In theory, it is possible, But in practice, these questions could be raised. Why is the employer letting you go if the job is permanent? And who is doing the job in your absence? Right? And those are the two questions that need to be answered. Sir? Hello?
But I can, like, let's say I leave if my dates are current in future, then I can find other employer who is willing to file the 485J.
I think so. But again, the key or the burning question to me would still be that departure, did it mean that you actually severed the employment relationship? If you look at it aggressively, there's nothing wrong with it. Because the law only says your 485 should be alive. It should have been pending 180 days or more. There's no requirement that you stay on that job for 180 days. So after that, if you get another job offer, you should be able to file a 485J. So if you look at it a little aggressively or by the letter of the law, it should be fine. Can they create issues? They can. Are these going to be insurmountable issues? If you get another employer to do supplement J, I don't think these are unsurmountable issues. I think you'll be okay. All right.
Okay, it's about staying in India for the time the dates are not current. So that is the concern.
Yeah, I'm okay with that. I just told you, as long as you have another employer with the same or similar job.
Okay.
All right.
Thank you. Thanks for taking the question.
You're welcome. Good luck. Okay, so we're coming towards the end of our questions. Question number 11. Green card denial for parents due to missing 864 pages, appeal and all. Yeah, this has become such a major problem with the USCIS. Every now and then we run into this too. While you sent your case and you're missing this page, there's no way to prove, even though we have a complete scan of what we submitted. The government is doing this a lot more than they used to. No, I would not do, ma'am, I would not do a 290B. I would not appeal. I would just refile the case. Even if they have been out of status, it should still be okay as long as they don't travel till they get their green card. I'm assuming you are a US citizen. I'm assuming that your parents are already in the US. So I think there should be no problem because immediate relatives of US citizens can be unlawfully present, accrue unlawful presence for even 20 years. They can still get their green card within USA as long as they entered USA legally, which they did. So I would not do an appeal. There's no appeal here. Press *5 if you have a follow-up question. Press *5. Okay. So let's look at the next question, which I believe is the second last question. A biotech in Boston. Currently working on H1B, received an offer from a new company. Their immigration lawyers have recommended the start date should be April 1st. Okay. That's how much time it will take for them to do the LCA and all. And I can start a job. I was wondering, what is the last date till which I can work in the current company? Oh, no. You can work with the current company even after the new H1B is approved. Okay. So new approval does not overrule your existing approval. There's absolutely no issue. So you go ahead and get your H1B transfer filed, and if you don't want to join right now, that's fine. Once the H1B gets approved, you can give your 2-week or 3-week notice, no problem. You can continue working for the old company. Okay. Press *5 if you have a follow-up question. Press *5. All right. This is from area code 937. Let's see. 937 is also Ohio.
Hello, Rajiv.
Yeah, Ohio. Go ahead, please.
Yeah. Yeah. Hello, Rajiv.
Hello, sir.
So I'm in the similar situation that I got laid off in August 2023. Then I got a job offer from an employer in September 2023. So I did my H1B transfer to them. And my petition is still pending because they did normal processing. And it is taking heck lot of time for get an approval.
Okay.
And I am moving into my another job, and my anticipated start date is March 4th. So currently they have filed my LCA. It has not been approved yet. So I'm in the similar situation, the question that you have asked, and I wanted to know that I am currently working for that employer. And if I have to leave that employer before my petition gets approved for the new company, would that be okay?
Yeah, that's
Because
okay
I'm thinking
too.
to take some vacation.
That's okay too. So you have two choices. Continue working for the old employer until the new H1B is approved. Then you give your notice. After the notice period, you join. Okay, no problem with that. The other choice is join the new employer after you file the H1B. But what if the H1B gets denied? You can still go to the old employer if they have not revoked your H1B. Normally they revoke. Those are the two choices.
Okay.
Okay.
So how do we know that they have revoked the H1B?
That's required by law. If they know the law or they are, quick about acting on the law, they should revoke.
They should revoke.
Yep.
Okay.
All right.
All right.
Good luck.
Okay. Thank you.
Bye-bye.
I do have some generalized questions. So I'll wait for them.
Yeah, let's just wait. Okay, so the last question is H1B, H4EAD, working on H4EAD after traveling abroad on advanced parole. Good question. So when I use my H4, let's see. I'm on H1B with a valid stamped visa till 26. Wife H4 renewal is also approved. She does not have a stamped visa. She enters on advanced parole. Will she be considered? See, I think she's still on H4 and H4EAD. You can double check with the USCIS. Go to the customer service. They'll put you through to the level 2 or tier 2 officer, who's an adjudications officer. I think she should still be considered to be on H4, H4EAD. That would be my guess. But I have no written support for this. It's just my surmise, my guess. *5 if you have a follow-up question on this. Okay. Anyone has any question, press *5. I'll call upon you in the order that you logged in, and I'll try to answer as many questions as I can. Right now I have 8 people with their hands up. No, 10 people with their hands up. 11 people with their hands up. Okay. Let me see how many I can do. So start with New York, which is area code 646. Hold on one second. Let me find 646. Show queue. Here is 646. Yeah, 646. Go ahead, please.
Good afternoon, sir.
Good
so
afternoon.
It looks like there is a class of people who are minor children who got citizenship under 320 INA when their parents naturalized. And when these kids left the country, and my son is one of them, there is no way to get a citizenship certificate. There are two options, the N600 and N600K, neither of which apply because you're already out of the country and you're already a citizen. So now I have a problem because I recently tried to renew my passport at the consulate abroad, and they asked for a citizenship certificate and put my application on hold, my son's application on hold. So what would be the legal remedy here? How can he get a citizenship certificate?
I have no idea. If nothing else, there is an option where you could get something called a boarding foil or a travel letter from the consulate. Okay, this is given in those cases where you have the status but you don't have the proof of status. Okay, so for example, if you go and you lose your green card. Okay, if you lose your green card, how are you going to come back? You go to the consulate, you say, give me a boarding foil or a travel letter, same thing. They'll issue you it. You come to USA, apply for a duplicate. I would say the same thing. Come and then apply for your naturalization certificate or passport here. Okay?
Okay. All right. Thank you.
Yeah, look at the travel permission option.
Thank you.
Good luck, sir. Okay, let's see who was next in my list. We have Ohio area code 513. Let me find you. Yeah, Ohio, go ahead. I can hear you.
Hi. So I'm a PhD student, third year PhD student.
Mm-hmm.
So I want to discontinue my PhD, and I'm in a situation like my school doesn't want me to continue my PhD. So is there any chance? What are options I have? I didn't take my OPT after my master's.
So basically,
And I want to stay in the state.
Yeah, I think the only option if you want to use your OPT, I mean STEM OPT extension, I hope that's what you mean, you have to join another PhD because you can't get an OPT at master's level again. STEM OPT, you won't.
I haven't taken. I have not taken master's OPT.
Oh, you have not taken
I haven't
first year OPT or STEM OPT?
I haven't used any of that.
Then you still have to join a degree. You can't get it without a degree. Okay. So if you think that you can just go and apply for an OPT now, you cannot.
After completing my master's, I have joined the PhD.
Yeah.
And after 2.5 years now, school doesn't want me to continue it.
Yeah, you can't. You cannot just apply for an OPT. There's a deadline, time limit within 60 days.
I have also.
Yeah.
I have also used my CPT, 11 months of CPT during my PhD. So if I join a different program other than PhD in a different university, will I be able to use my CPT if I transfer the credits of my current PhD?
There is no limit.
Master's?
There is no limit to CPT. There's a limit to OPT. There's a limit to STEM OPT. There's a limit to getting OPT after using CPT. But there's no limit to CPT. As long as your coursework requires it.
We want to. I wanted to do full-time CPT.
Yeah, as long as your coursework requires it, you can do it. No problem. There's no limit to CPT because CPT is like coursework. It's a part of your education. It's not a work authorization. Okay?
Okay. So, they told we should only do CPT for less than 12 months, right?
That's only.
But otherwise, after.
No. Okay, I'll make this short. Otherwise, we're going to keep talking about this. I'll make this short. Listen to me very carefully. There is no limit on CPT. Go get it. Okay?
Okay.
Yeah. Good luck.
It will not affect my OPT, right? After that?
Yeah, you cannot get an OPT if you have used CPT for a certain number of number of months, but there's no limit on CPT. Sir?
Okay, so
I'm going to have to go on. Yeah.
So,
I just gave you your answer. You're just not willing to take it. I just gave you your answer. You can take any amount of CPT. There's no law that requires only a certain amount of CPT. Okay?
Yeah, if I use more than 12 months, I will not be eligible for OPT.
Yeah, you won't get OPT. That's a different ball game. But CPT, there's no limit.
Okay.
All right. Good luck.
Okay.
Yeah.
Thank you.
You're welcome. By the way, just Google studyinthestates.gov. There's a website from the Department of Homeland Security. It's called Study in the States. This has all the information that you need. Okay?
Studyinthestates.com.
Yeah. It's actually dhs.studyinthestates.gov. Good luck. Illinois, go ahead, please. Illinois, area code 312.
Hey, can you hear me?
I can.
Hello.
Yes, I can hear you.
Hey, so yeah, I do have a question actually. It's based on this morning. You had a group call with you this morning at 7:15. It's basically.
Oh yeah, I remember. I
just to give
remember.
you a
I
quick,
remember. I know who you are.
Yeah.
Go ahead.
So I'm in the. Yeah, thank you. Yeah, I'm in the same group, and my question specifically related to my situation is that I am thinking of going into a spousal related green card arrangement with my long-term partner. So I was wondering if there are any suggestions on the best way to go ahead with it, given the circumstances that you're aware of.
Is she or he, are they a green card holder or a U.S. citizen?
Citizen.
Yeah, then it's very easy. You can get married, and even if you are out of status, it is not a problem for the spouse of a U.S. citizen. You can get married and immediately apply for I-130, I-485. Wait for your EAD, and then you can start working.
Is it recommended in this scenario to have an attorney or a lawyer to represent?
Well, see, for family-based cases, my advice to most people is, if you have more time than money right now, do it yourself. If you have more money than time, let a lawyer do it. A professional can still do a job better than you can. But I don't think of family-based cases as being particularly difficult to file even by yourself. Okay.
Okay. Is there something your team can help with if needed?
Yeah, we have at least 3 people who work on family-based cases full-time. Yeah.
Okay, I will set up another consultation.
Oh, you don't need to set up a consultation. Just send me an email. And if you have any questions, put them in there. As a part of our representation, when we take on a case, we don't charge for consultation on an ongoing basis. We just,
Okay.
So, but if your questions need to be answered anyway, just remind me, Sir Rajiv, we were doing a consultation before we hire you. So when we send you the paperwork for the actual representation, we'll take out $200 for the consultation out of that. So no worries. Okay.
Yeah.
So just remind me.
Just a quick last question is that can I, if the service is terminated, can I go back to F1 status?
If the service is terminated, so remember we talked this morning and I said to you guys, all of you, that you can just go to F1 change of status if you file within the grace period. Okay.
Okay.
So, but remember, the H1 should be still not revoked when you file for change of status. If it is revoked, then that option no longer remains. Okay.
Okay. Thank you.
You're welcome. Good luck. Area code 903. 903. I think it's Texas. 903.
Hello, sir.
Yeah, go ahead, please.
Sir, I am in a non-profit H1B with a previous company, and it was my initial H1B was valid till the 3rd of January 2024, and we applied for a renewal during August 20th on a premium processing, but it came for a RFE. Then another non-profit company acquired us on 1st of September. So before my renewal H1B approved, my company got changed, but the lawyer went and answered the RFE with a previous company name itself, and it got approved. The renewal got approved, and I'm in the renewal H1B now. Now I'm planning to go India for my stamping. My work has not changed. My nature of work, my job description, my designation, my manager, everything remains the same. Only the company name changed because we got acquired by another non-profit company. What are the documents I should take, or is it anything I should do it now? Because I I assumed, it is my mistake, I assumed that it was just we got acquired and nothing else happened. So we did not submit any other paperwork.
This is a very difficult question to answer. There are too many moving parts. Okay. So you need to get together with your lawyers.
Okay, sir.
Figure out, see, sometimes the acquisitions are absolutely seamless. So for example, you have a company and I, the acquirer, go and take 51% stock of the company. Employees' jobs remain the same. That's zero impact. On the other hand, another acquisition is I come and take over some of the assets of the company, not all, some of the liabilities, not all. That's a lot more complicated. So your lawyers need to sit with you and figure out, it is not an insurmountable problem, but it's not something I can resolve for you. It has to be done by somebody who has reviewed the merger and acquisition agreement. Okay?
Okay, sir.
Good luck to you, sir. But don't worry, it's not unmanageable. It can be taken care of. Don't worry so much about it. Okay?
Because my new H1 started from 4th of January. It's like almost 28
it's
days.
Not the end.
I was just worried.
Oh, no. Even if you worked without authorization, it is not a permanent issue, not a permanent problem. Everything can be fixed. Don't worry. Okay?
Okay. Thank you so much, sir.
You're welcome. You're welcome. Good luck.
So much.
You're welcome. Area code 669. Go ahead, please. Area code 669.
Hi, Rajiv, sir. This is Ajinkya. We've spoken before. I am the person who did not receive his approval notice yet, and I have put in an application for that duplicate copy.
Okay.
And I am on that 60-day grace day period.
Okay.
So I just had 3 quick questions.
Sure.
From going from an H1B to V1B2, will the approval notice courtesy copy or the receipt notice of a duplicate copy be enough?
Yes. What else?
Okay, perfect. Because I have both. And the second question is, once I apply for the B1, B2, my clock stops or the grace day period stops the moment it's received, or the moment I get a receipt notice that they have received that form?
That's an inaccurate statement. The grace period continues to tick. What stops is any possibility that you'll be considered illegal. Because the moment your application is received by the government, as long as it is within 60 days, you are now in lawful status. Okay, what is called authorized period of stay. All right? So that's how it works.
Okay, so as long as it's received within 60 days, I am in status.
It's called authorized period of stay.
Like it leaves the
Yeah. You are legal to stay in the US. No problem. Okay.
Okay, and I'm like 25 days in right now. I'm just trying to understand, is the last 10 days of a 60-day grace period enough time to apply?
Yeah, so
you know my scenario with the approval notice.
If you look at my blog entry on this on immigration.com, I have recommended if you are going to do it online, do it by the 55th day, 55. But if you are doing it by mail, do it by the 50th day. Okay, that gives you enough room for things to go wrong, and because packages can disappear. Electronic filing, the advantage is right there what's going on. Okay.
Okay. Thank you so much. For the B1, B2, you mentioned application is received and that within 60 days, that means I am in status.
Yes.
So application received means just that the form has been delivered?
Yeah, the package has been actually physically received. Physically received by the USCIS.
Perfect.
All right. Good luck.
And does your team do this process from H1B to B1, B2?
Yeah, I was just talking to somebody this morning and I found out that we charge $800 fees for it. Personally, I think it's a waste of money, but if you guys want us to represent you, many people have hired us for whatever reason, peace of mind, I guess. So if you want us to, just go ahead and send me an email, okay?
Okay.
Yeah, good luck.
Understood.
All right,
Thank you
bye-bye.
so much, sir.
Bye.
Thank you.
You're welcome. Okay, let's go to area code 979. Go ahead, please, 979. And just for your count, I still have, I think, 7 more questions to go. More people started raising their hands. But no problem. I think I'll be able to finish it all today. Go ahead, 979. Go ahead, please. 979. Go ahead.
Hello, Rajiv ji.
Ji.
Yeah. So I have an employer who is willing to transfer my H1B, and they are a remote-only company, so they don't have a physical location. So, is there a way that I can be hired as a remote worker without specifying a specific address?
Oh, absolutely. You have to give your home address, but today I just talked to an employer who has a home office. They are starting a product, but they have all their employees are working remotely. That's perfectly okay. No problem. Okay.
So, if I want to keep changing my home,
you can't do that. You can't do that. No. Your H1B is tied.
Got it.
Yeah, your H1B is tied to a location. In this case, it is home location. If you move within approximately 50, ma'am, let me finish. If you move within approximately 50 miles of that approved location, it isn't too complicated. It's fine. But if you start changing states or you start moving more than 50 miles, you have to do H1B amendment every time you move. Okay?
Got it. And I had one more question. With approved I-140 with EB to NIW, so how does the grace period look like in that case if you are fired from your current job?
No change in the grace period. Still the same.
No. Okay. Got it. Thank you so much.
You're welcome. Good luck. Okay. Area code 716. 716, go ahead, please. 716.
Hi, my name is Smith, and I want. Hello.
Yeah. Go ahead.
Am I audible, right?
Yes, you are.
Hi. So my education approved, but my company says that it will take still 5 to 6 weeks to mail me. But I have to travel to India for my personal reasons. So can I, worst come worst, if the letter doesn't come to me before my travel, can I tell someone to send? Is it safe to travel to India?
Is this an H1B approval you said? Hello?
Yes.
Yeah. H1B approval can be, it can be emailed or mailed to you. No problem. You can even take a scanned copy. No issue.
Okay, but I haven't got the physical copy for the interview and stamping. I need the physical copy, right?
No, you only need a copy. If you look at the notice itself, it says you are only required to have a copy. The original employer retains. Okay. So, lot of times CBP and you. Sir, let me finish. Would you please let me finish? A lot of times, Customs and Border Protection or the visa officer might say, I need the original. Say, Dufus, just read the notice. It tells you, I can only get a copy. I can't get the original. Okay?
Okay.
That's how it works.
Okay. And my receipt notice also doesn't contain the petition start date and end date. So can I book the appointment for stamping?
I don't know the answer to that question. I have never booked an appointment. I have no idea what it takes. So people do it. I don't know how they do it.
Okay.
But that's something you're gonna have to figure out. I have no idea. All right.
Okay.
Good luck.
Okay. Thank you so much.
You're welcome. Okay, area code 470. 470, go ahead, please. Area code 470.
Hi, Rajiv ji. It's me, right? Just wanted to confirm.
Mm-hmm.
470.
Yep, it's you.
Okay. Perfect. Thank you so much. And thanks for hosting these sessions.
Of course, my
So
pleasure.
I'm in a pickle right now. My job is terminated because of the recent wave of layoff. And technically, it will be my last day at my job is tomorrow.
Okay.
And I reached out to my HR to see if, what processes they're going to put in for USCIS and all of that. I haven't heard back. So I don't know if they're going to provide me any immigration services of any sort or return flight ticket or any of those obligations. So that's part of it. The other part is I have approved I-140 with priority date December 2016. So I'm in the worst scenario, I'm thinking of changing it to B2 or visitor visa, and so that I can continue to, have lawful presence here. So having said all of that, I'm also working on a couple of other things as a side project. So I do stand-up comedy, as well as I'm building an application, a mobile app to help out the stand-up comedy community, in short. So the app is still in development, and it might take a few more months to where it's at a place where I can pitch it to other investors or to the the users itself. So my question is, how can I use my company to sponsor my H1, because it's lies in the same industry, because my job was sales engineer and the app itself is a software. So I'm
I discussed
selling it.
I discussed this
in
the beginning of the conversation. The first issue I discussed today was entrepreneurs' options. Were you here when I talked about it, or did you join later?
I might have missed the starting few minutes.
Yeah,
but,
I want you
I
to
can go back and listen.
Yeah,
to
I want you
some
to
of those.
wait. Monica or Deepa should be able to post this by tomorrow. I've talked about it, and briefly, it might be possible, but right now it's a little dicey. But marta kya na karta wali baat hai. If we get stuck in a corner, then by all means, karna pada to karoge. Nothing illegal about it. I mean, we're not doing anything illegal. It may be unfeasible, but not illegal. Definitely worth a shot, definitely worth thinking about. Listen to the conversation that I had in the beginning of the discussion. And I'll come back to me next week, we can talk again. Okay?
Okay. Thank you so much for all the help.
You're welcome. Good luck. Okay, I just wish there were more hours in the day sometimes. Okay, area code 937. 937, go ahead, please. Area code 937. Yeah, go ahead.
Hello, Rajiv.
Hello, sir.
So I have a question for my friend. He got B1, B2 in 2016, and then he came on F1 in 2019, and he has an H1, and he's planning to go back permanently to India.
ठीक है.
So the question was like he's been through 3 visa statuses. So he wants to make sure that his B1, B2 is still valid after getting those 2 visas.
Yes. Unless it is physically cancelled, it is still valid. No question.
Okay. It's not cancelled.
Yeah. So he can travel on that.
So it is valid.
He can travel. Absolutely. He can travel on
He can travel.
Yes. Okay.
Okay. So another question that I had was I spoke to you a few minutes before, but I have a petition pending and I'm getting a new offer. So is there any way that I can travel on the pending petition out of United States?
You can. You are talking about H1 to H1 transfer, right?
Yeah, correct.
Yeah. So you can just coordinate with your lawyers. When there is an extension or a transfer pending, you can travel. You must have a visa stamp, though. You have a visa.
I have petition.
Yeah, you have a visa stamp, though, right? It's still unexpired.
Yeah, I have my first. I have first visa stamp.
So yeah. You can travel.
And this is my second.
Yeah, you can travel. Just talk to your lawyers about the details.
I can travel on this.
You can. All right.
Okay.
Good luck, sir. Guys, hurry it along, please. Come on. Chop. Can't wait forever. Area code 571. Go ahead, please. 571. That's my
Thank you so much for
neighborhood.
answering my question.
Gee,
Hey,
go ahead, sir.
hey, thank you so much for answering my question. So I currently have, and I was laid off back on December 19 from my previous company, and I have an I-140 and form that's approved.
Okay.
And since my 60 days grace period is about to end in like the next 15 days, my plans are, my wife is also on H1, so I'm thinking of filing for like a dependent as an H4 on her visa. Is it possible to come back on an H1 once if I get an offer in the future?
Yeah, absolutely. No problem at all. Happens all the time. Because change of status is not irreversible. Change of status is perfectly reversible. No issue. Okay. Sir, are you done?
Affect my sorry, I'm saying this. Will that affect my perm or I-140 by any chance?
You have to start all over again whenever you change employers. But you keep your priority date, no question about it. Okay? I can't hear you. Hello?
That's all.
Okay, good luck. Okay, folks, just hurry up the questions a little bit. I think there's maybe some problem with the lag. Okay, my neighborhood, Washington, D.C. Go ahead, please.
Yeah, hello, sir. Thank you for your time.
Of course.
And I wanted to share, I have more of a situation than a question. So my H1 got approved in 2022.
Okay.
And I came here to India and applied for the same thing in 2023.
Okay.
And they disapproved that, saying because of history, which was basically in 2017, I had a couple tickets for traffic and criminal. They were related to marijuana, so that was very much then approved within Virginia, which is basically your neighborhood.
Yes.
And I am from DC myself, but I got those tickets in Virginia. And so now I'm at this situation that I wanted to know what should I look forward to doing in this situation to, get my H1 campaign cleared.
I don't remember the exact law on this issue, although I've dealt with this situation before. So the Babaji ki booty is weird because it is legal in many states, but it is illegal under federal law. So therefore, unless the federal law changes, I think your inadmissibility cannot go away. There is a waiver called 212D3. Likh lo isko. You can Google it. 212 D as in doctor.
212D3.
Hanji. D as in doctor number 3.
Okay.
See if that waiver can work for you, because what will happen is if you get that waiver, you can then come and work in the US, although you can't get a green card, but you can keep extending your H1B as long as you can. Okay.
But I was wondering, is there a way to get this expunged? As they have been all cleared back in 2017, I had a lawyer and everything was sorted out.
if you
they actually dropped the ticket, but
okay, hold on. That's a much more complicated situation. So if you had a conviction that cannot be expunged for immigration purposes, but if you never pled guilty and there was no conviction, then that should not be a problem. So. Okay. What I would what I would recommend is, if you pled guilty, then I think you have a problem. You can just take a consultation, talk to a lawyer who. Where were you arrested? Was it in Virginia or DC?
It was in Fairfax County.
Fairfax County. So talk to a lawyer in Virginia who does deportation defense. Okay. You want to talk to somebody who does deportation, ask them what you should be doing, because they are the ones who typically deal with criminal law and immigration law at the same time. Okay. There's something called, write this also down.
Okay, great.
Write one thing more down. There's something called the writ of audita querela. The writ of audita, AUDETA, audita querela. Second word is querela. QUERELA. R-E-L-A, I think. The writ of curata rela. What that does is, your Virginia lawyer might be able to actually get the conviction reversed. Expungement is not enough, but if the conviction is reversed, then you can be admitted without any problem. So look into those two options. Once again, just talk to them, look into 212D3 option and see if the writ of audita querela can be filed for you. Okay?
Definitely. Thank you so much for your time. I appreciate it.
You're welcome. Good luck. Okay, let's go to, we have 3 more people left. Area code 269. 269, go ahead, please. Area code 269. Hello.
Rajiv, can you hear me?
Yeah, I can. Go ahead, please.
Hello.
Yeah, go ahead. Hello? Oh, something happened. Let me see what happened. Area code 269.
Hello?
Yeah, 1 second. I think I screwed this up. Hold on. It's my fault. 269, hold on. I'll come to you. Okay? I think I messed something up. My apologies. 269. Let me get to you first. 269, where are you? Okay, here you are. 269, I just unmuted you. Go ahead, please. 269, go ahead.
It's Rajiv ji.
Ji.
Thank you.
Mm-hmm.
Yep. Thank you, Rajiv ji. I just had a question regarding the new H1B final rule that's coming in.
Mm-hmm.
I read that there is the new unique beneficiary centric process is based off of passport or travel document, right? So instead of selecting by registration, are they going to be selecting based off of the passport number or travel document?
Yes, they are.
And how is that going to work?
So basically, still multiple companies, unrelated companies can apply for you, but they will send an approval to all the companies. And if all of them want to file for your H1, they can, but you are only counted once in the lottery system, not 5 times. Okay.
Oh, okay. So multiple companies can apply on my behalf, and it will be then the choice of the employer, or choice of is the choice dependent in my hand or the employer's hand?
So if let's say you file through 5 companies, right? 5 companies unrelated to each other, they applied for you. If you get selected, it's not the company that gets selected, it's you get selected. All 5 of them can file for you.
Okay.
All 3 of them can file, 2, 1. But it's your choice who you want to join.
Okay. I get it.
That's how.
And one more question, if you don't mind. The organizational accounts that they are going to create, are the employers going to get access to it?
Yeah.
And
just
if the employers get the access to it?
Yeah. Employers will get access, but not the employees.
So, okay. I get it.
Okay. Good luck.
Thank you.
You're welcome. Yeah, guys, immigration laws have been made so complicated, unnecessarily so. Okay, let me go back to 716. Yeah, 71. I don't know. What am I doing today? Okay. 716, I just unmuted you. No, sorry, 269, I just unmuted you. Oh, that was 269? No. Sorry.
Oh.
No, hold on. I have to look for 716. There are so many people still waiting. Okay, I'm surprised. Back to Buffalo, New York. Here you are. I see you now. Okay, 716. Sorry about that. Go ahead, please. Ji.
No problem. Thank you, Rajiv, sir, for taking my question. So I did message you on LinkedIn as well, but mine would be a pretty short question. So I did apply for a change of status to B2 in November 18th last year, 2023. And my grace period would have ended by December 1st. I received my B2 approval on January 24th.
Very nice.
But the approval notice says the valid period is from January 24th to the requested end date.
So in other words,
so my question was,
did they eat away some of your days? Is that what happened?
Yes, because I had requested it from November 30th to May 30th,
Yeah.
but my approval notice, it says
Yeah, this is
from the
not a
date
big
that
deal.
it was approved.
Yeah, don't worry about it. It's not a big deal. Those days, actually, it's now in the USCIS policy manual. They recently updated it just a couple of weeks ago that in a situation like this is how they'll approve it, and the days that are in between, consider them to be forgiven.
Okay. So I don't have to worry about the
Not
days
at
that were
all.
paid until the 24th of Jan.
Not at all.
Okay.
Make a nice cup of ginger tea, relax, enjoy yourself. You're fine. Okay.
Yeah. Thank you so much,
You're welcome.
Rajiv sir. Yeah.
You're welcome.
Have a good day. Bye.
You too, ma'am. Bye-bye. Last question. Phew, today was a big one, guys.
Bye.
Area code 937. Please go ahead.
Sorry again, I forgot the question.
कोई बात नहीं. बोलो. Hello. Oh, one more time. Let's try again. Hello. Can you hear me? Area code 937. Yeah. Go ahead, please.
जो मेरा जो नया कंपनी है जहाँ मैं रहता हूँ अभी वहाँ से वो 55 miles away है.
Did you say hold on, back up. Did you say 55?
Yeah, 55.
Okay. All right. So are you worried about your H1B being too far outside the normal commuting distance? Is that what you're thinking?
Yeah, because they are filing my LC on the office address, so I raised that concern.
Well, you know,
wanted to consult on.
Look, if you look at the regulations, they don't say 50 miles. The regulation said normal commuting distance. Okay. In New Jersey, New York, I have won cases with even 90 miles. Okay. So if it is normal commuting distance, how do you prove it? You talk to your lawyers. If it is normal commuting distance, which it appears to be, I wouldn't worry about it. Okay?
Okay. All right.
Good luck.
They are considering me as an hybrid worker. So
Yeah.
That is the reason they're filing LC on the office.
Yeah, like I said, if you look at the regulations, they say normal commuting distance. ये 50 miles तो हम लोग ने बना लिया है. Just normally understood it to be like that. Okay.
Okay. Okay. That is it. Yeah. Thank you so much.
Good luck.
Have a good day.
Good luck, you too. Folks, as always, it's great talking to you. I'll see you again next Thursday, hopefully on LinkedIn. Take care, everyone. Bye-bye.